All right. And we're back. So this is Military Law Talks. And this is a channel about military law and current events and historical military cases. Again, this is for entertainment, educational purposes only. No legal advice is given. And in this stream, no medical advice either. So this is kind of a difficult one for me. I have to be honest. This is deeply personal. Myself, and I'm sure most people watching this were deeply affected by the military COVID vax mandates. And most every person that's dear and close to me were in the military too. So many people were profoundly affected. And so I completely understand the gravity of the video that I'm about to do and know that it's not easy. But we're going to talk about it, and we're going to talk about hard things. And really, we're going to talk about the new EO that the Trump administration has put out to reinstate military members who were involuntarily, I'm going to emphasize on the word involuntary, voluntarily left. They can come back as well, but involuntarily separated due to the vaccine mandate, they can come back with back pay. But there's some caveats with that, so we'll talk about it. But before we get into that, let's talk historical. We kind of got to go back and see kind of the history of what happened. This historical context, I think, is really important to understand the legalities or illegalities behind what happened, in 2020, 2021, 2022. So again, this is deeply personal, and I want to read something that I didn't write, but someone else wrote that I think really captures really kind of not only the physical, but also the psychological distress that this caused, and the moral distress that this caused. That there were many of us in the military who felt like, they were being pulled in two different directions. That their deeply held convictions was telling them one thing, and their obligation to their job, to the uniform that they love, to the country that they love, was pulling them in the other direction. So I'm going to share words from someone else that I thought really fit what we're talking about. So this is from Robert A. Greene. He's also written a book, which I will link below after the stream is over. He says, "Next, I was ordered to take a medical intervention that I neither wanted nor needed, and that also violated my deeply held religious beliefs. This order to take a COVID-19 quote-unquote vaccine was issued in support of a political agenda, and despite clear data demonstrating very little benefit for the overwhelmingly young and healthy military population. On January 7th, 2022, after refusing the quote vaccine and an unlawful requirement to accept emergency use COVID-19 screening tests, I was fired from my position leading a 650-person security squadron for the U.S. Navy, and I was sent home with no further responsibilities beyond calling in daily to a superior officer 6 states away. I was threatened with disciplinary action and had some very tough conversations about what would happen to me in the event of a court-martial and prison time." Later he writes, "The looming court-martial and involuntary separations hanging over the heads of so many service members in 2021 and 2022 never came to fruition for me. The military's stated goal of kicking me out, along with tens of thousands of other service members, was thwarted by several injunctions issued by multiple federal courts. Months later, Congress, despite the DoD's efforts to the contrary, finally rescinded the COVID-19 vaccine mandate. Many of those who had not yet been kicked out over this unconstitutional policy were put back to work. After 7 months of exile, I too was put back to work. but not until my own stellar career was ambushed by leaders who took away a higher education Naval War College opportunity, rejected the meritorious service medal I was put in for, and gave me multiple negative performance evaluations based on nothing more than my conscientious objection to an unlawful order and in direct contradiction to my stellar performance record. We may have temporarily pushed back the rapidly accelerating tyranny of a runaway federal government, but the fight is far from over. The damage to readiness perpetrated by our own leaders begins with the 8,000 service members separated over the vaccine mandate, a great many of them who filed religious exemptions, religious accommodation requests. We are in the midst of one of the deepest recruiting droughts in U.S. history, and the DoD has made no effort to restore these members or offer back pay, despite offering other recruits up to $115,000 to recruit. This implication is obvious, and it boils down to the DoD insinuating that, quote, religious service members need not apply. All of this amounts to a deep betrayal of trust, but perpetrated by senior military leaders. The ranks of those harmed go far beyond the 8,000 kicked out over the mandate. There are thousands of victims who are still in the service, still dealing with the fallout from past persecutions and struggling with the ongoing harassment based on their choice to stand up for their religious beliefs and bodily autonomy. These victims include many who were verbally abused for their religious beliefs, placed under weaponized mental health evaluations, and a great many, like myself, who receive negative paperwork or non-judicial punishments. I highlight the current situation of a Navy pilot as just one example of the thousands of service members still dealing with these harms. Before the vaccine mandate, this Navy pilot had signed for a bonus of $60,000 in exchange for agreeing to a 3-year department head tour of duty. When the mandate came down, he exercised his right to refuse the vaccine and was promptly removed from his department head position, received other threats of punishment, and had his career completely derailed. Despite the fact that the mandate had been rescinded, the Navy is now perpetrating an additional injury by attempting to force him to repay the $60,000. After the Navy chose to sideline him for 2 years, they now claim that the unlawfully fired Navy pilot is the one who is breaking the department head contract by not agreeing to a new full 3-year tour of duty. And again, the executive order that the Trump administration has released does not fully address the harms. And I'll explain why, at least from my perspective. And but this is from Robert Greene, Defending the Constitution Behind Enemy Lines. I will link his book below. And so for me, I just felt like that was a well-articulated thought of kind of the harms of what went on. Personally, I didn't take the vaccine. I put in a religious exemption, just so you know where I'm coming from. But I know, countless friends and people I'm close to who felt like they had no choice, who took the vaccine and they didn't want to. And so, but just know that unfortunately, the military kind of has a history of this. So I'm just going to give kind of a historical background, and then we'll get into some of the cases, and then we'll talk about the executive order. So historically, this idea of informed consent and bodily autonomy, obviously rooted in medical ethics, but also in the Nuremberg Code. And so during the Nazi regime, there was forced medical experimentation on people in the concentration camps, not only Jews, but also, religious minorities, gypsies, other people who were put in concentration camps. And there were crazy medical experiments that were run on these individuals, obviously without their consent, knowledge, and they had no choice in the matter. And so part of the Nuremberg trials, which I do plan on doing a series later in the year on the Nuremberg trials. Part of it, there were doctors and nurses that were on trial, and they were on trial for this medical experimentation. And so that was part of the crimes against humanity, is these medical experimentations on people who without their informed consent. So because of that, out of the Nuremberg Code, there's this idea that if you're going to do medical experimentation on individuals, they have to give informed consent. They have to agree and understand the risks of what they're agreeing to. And so, but unfortunately, the military has kind of a sketchy background of experimenting on troops. So there's cases out there, and maybe I'll do another stream on the cases that show this, but there are cases out there where military members were exposed to nuclear um, materials without any sort of informed consent. I mean, some of them were asked to just stand out there while they let off a nuclear bomb, and then the troops were exposed to it, and they were just trying to see like what's going to happen. There's other cases of soldiers who were doused with LSD, who were experimented upon by a joint venture between the CIA and the military, and they had no idea what they were getting. They volunteered for a special assignment, but they didn't know that they were going to be given LSD and then be monitored and see what happens when they're on LSD. There's also been use of lots of chemicals, right? Chemical exposure to all kinds of unknown things. So my dad was in Vietnam. He was exposed to Agent Orange. So he's on the Agent Orange registry. And I'm sure myself and a lot of people who are going to watch this stream, we're in Iraq or Afghanistan, and we're on the burn pit registry. I'm on the burn pit registry. I'm sure most of you are as well. So, I mean, I understand in a war zone, you kind of don't know what you're getting yourself into, but maybe we should not knowingly expose our troops to things that are dangerous. And then in the vaccine realm, so there was the anthrax vaccine that was first required of troops in the first Iraq war, so early 90s. And there were a lot of bad side effects. So they call it Gulf War syndrome. And there's some research to suggest that's potentially it's vaccine side effect. So I don't really know what causes neurological and a bunch of other issues. And so it could have been from this anthrax vaccine. So there was a lot of lawsuits in the 90s involving the anthrax vaccine. And so we're going to take a look at one of them. And so I'm going to find it to share my screen. But so there were... if I can find it, I think that's the wrong one. That's one of them. Let's find. Nope, that's the wrong one. All right. Bear with me for a second while I find the right one to share. So in the 90s, so these lawsuits were filed in the 90s, and the one that I'm going to talk about was actually decided in 2003. And that's where we have a historical understanding and a precedent for the cases that were filed when the COVID-19 vax was mandated. And so let's see if I can share my screen now. There we go. Okay, so interestingly enough, so this is filed in the DC Circuit, Judge Sullivan. So you may know his name. He's a judge in a lot of the January 6th cases. So, and not a very friendly judge to January 6th defendants. So interesting that he was the judge in this case. But there were lots of plaintiffs who were members of the on active duty or National Guard, and also civilian. There are civilians who are involved in this lawsuit as well, who either were mandated to take the anthrax vaccination or had already submitted to, I think it's 5 rounds. I think I got like 1 or 2 of them before I went to Afghanistan, but I don't think I ever got all 5 of them. And so they're bringing this lawsuit because they said that this anthrax vaccine was an experimental drug. It was unlicensed for its present use, and it was under emergency use authorization. Doesn't that sound familiar? Okay, and so they're saying that the order to get these violated federal law. So there's a presidential executive order. There was a 10 USC. So this is a statute that's a law passed by Congress, and DOD regulations. And so we'll get into why. So just give some background. So there's background about the case. Essentially, the anthrax vaccine had been originally licensed by the NIH, But then later, the FDA took over licensing vaccines, and so they said that there was not enough research to give it FDA approval for inhalation anthrax. There wasn't enough information to say that this was a quote safe and effective for inhalation anthrax, and so it didn't have FDA approval, and so it did or for not in for in inhalation anthrax. That's what it didn't have approval for, and so there was. So it kind of goes over the legal background. So the case says that back, after the Gulf War, like I talked about, there was unexplained illnesses. So Congress passed a law prohibiting investigational drugs. I can't say the word. English is hard. Drugs that were unapproved for their intended use to give to service members without informed consent. So essentially, unless it's FDA approved, service members had to give informed consent to take it. They couldn't be mandated to take it. However, a caveat, that informed consent can be waived by the president. So the president signed an EO into law. So 1999, who would that be? Clinton, probably. Maybe George. Yeah, Clinton. It would be Clinton. Sign an EO essentially saying that the DoD has to obtain informed consent from each individual member of the armed services before administering these investigational drugs, under which a waiver of informed consent is only granted when, quote, absolutely necessary. So, I mean, I don't know about you, but I've never gotten informed consent for vaccines, particularly like pre-deployment. They just, put it in your arm. So, but if it's under emergency use, have to get informed consent unless the president waives it. Okay, so then it talks about this mass program to inoculate people for anthrax, for inhalation anthrax. So then this lawsuit came up. And so some people who were involved in the lawsuit had taken some of the series, some had refused. And so they're asking for an injunction. And ultimately, I'm going to skip to the bottom of this. Ultimately, the court does give this preliminary injunction. They say that essentially they're likely to win on the merits, that the drug itself didn't have FDA approval, there was no waiver, and so as a result, the DoD was violating the law, the executive order, and the DoD directive because they were trying to mandate service members and civilians to take this biological, that the vaccine that was not FDA approved, and there was no waiver of the informed consent requirement. And so the judge says, the women and men of our armed forces put their lives on their line every day to preserve and safeguard the freedoms that all Americans cherish and enjoy. Absent an informed consent or presidential waiver, the United States cannot demand that members of the armed forces also serve as guinea pigs for experimental drugs. So he granted the order. So I thought that was pretty strong language. So that gives us kind of our background for the COVID vaccine. And so what happened, right? So when it initially came out, it was under emergency use authorization. So it wasn't required. It wasn't mandated because of this, because there was federal law. The president hadn't waived. It couldn't be mandated while it was under emergency use authorization. And so then, right, Secretary Austin, right, so Trump administration was out. Then Biden administration is in. General Lloyd Austin was the Secretary of Defense. And so he had indicated once the FDA was going to give approval to the COVID vaccine, he was going to mandate it. And so let me find. see. I think this is the right one. Yeah. Okay. So then here's the order that came down. I think that's the right one. Okay. Yes. So here's the order that came down August 24th, 2021. It said mandatory vaccination against COVID-19 will only use COVID-19 vaccines that receive full licensure from the Food and Drug Administration, the FDA, in accordance with FDA approved labeling guidance. And that's because this case law that I just read and federal law, executive order, and DOD directive. And so, in my mind, and on a lot of the minds of people who were refusing the vaccine, was, well, okay, so you're requiring us to have the FDA approved vaccine. But if you remember, the FDA approved vaccine was commodity and it wasn't available. And then they came out with another order that said, well, I mean, they're interchangeable. So the Pfizer BioNTech one, that's the same as the FDA approved one. And so let me find that order. But there was a lot of lawsuits or around that because legally they were different. The only FDA approved at that time, later others were FDA approved. The only one that was FDA approved wasn't available in the US. And so that was subject of litigation. Let me see if I can find the lawsuit. All right. Or here, I found an article that talks about it. So let's look at this. Let's pull up this article. Okay, so it talks about in the memo that it's mandatory now, but you're only going to use the full licensed FDA approved one. But the problem is the commodity. I don't know how to say it. I'm probably totally butchering it. Vaccine product that was approved by the FDA is not available anywhere in the military health system. It wasn't even production. It wasn't available in the U.S. And so then there was another memo that came out that said, well, these are interchangeable, but the formulation was different. So it says, according to the formulation comparison sheet, there was a different formula. It was a different drug. And this article points out that informed consent is required by both federal law and international law under the Nuremberg Code, but it's impossible to give informed consent to receive a medical ingredient that was shrouded in secrecy because the label had a ingredient that was redacted. So that's what that's talking about. All right, let me find. Sorry, I'm going to stop sharing my screen and find one of the lawsuits that discuss this. All right, here we go. All right, so there are several lawsuits. One in particular that I'm going to discuss that I followed kind of up and down the Supreme Court. So it was several Navy SEALs that sued Lloyd Austin, right, DOD, and it went up to the Supreme Court on preliminary injunction, partially granted, partially not. So, and then came back down. Ultimately, it was never resolved because Congress withdrew the vaccine mandate and the case was dismissed. It was never decided on the merits. But this is from a district court filing. So let me share my screen and so you can see where I'm talking about kind of the differences. So this is a footnote where they talk about, that memo that came out that it was the same formula, interchangeable for medical purposes. But it says the plaintiffs question whether these two products are in fact chemically identical. There's like a redacted portion of the drug. So we didn't even know the full ingredients. The ingredients were different when you compare the two. So they're saying that, hey, this is a different drug, right? So it's not the same one. And even down here, the FDA concedes that they're not. They may be medically indistinguishable, but I think that's, I don't know, I'm not a doctor, but if you have different ingredients, I don't know how you can be medically indistinguishable, but they're definitely legally indistinguishable. Let me explain why that's important. So, for obviously, right, it would violate, hey, if we can't have informed consent, and if there isn't an FDA approved one on the market, everyone who refused argued that, well, I can't be forced to take one that's not the FDA approved one. We know that that didn't play well. Still, people got kicked out. People got court-martialed. Lots of people got general officer letter of reprimands, and then separated involuntary. So they got bad paper and separated as well. And so that's so. Like I said, this is legally there is a difference between the two, and it felt like a bait and switch, right? So like, well, it's FDA approved, but not really. And so, like I said, we've never had a resolve. These lawsuits were never resolved because the later Congress passed the NDAA that repealed the mandate, and so we never got a difference. But if you are civilians, you could argue that there's absolutely a difference and try to sue. But here's the problem. Here's the caveat, and here's why they did what they did. So, the drugs under emergency use authorization had PrEP Act immunity. So Congress passed a law that said these drugs, all the drugs from Operation Warp Speed, these vaccines, they're not really vaccines, but that they had immunity. So Pfizer and Moderna, they had immunity. So that means they couldn't be sued. So if you had a vaccine injury, you couldn't sue. And then for FDA approved drugs, vaccines that are on the childhood vaccine schedule, in the 80s, they passed a law that granted them immunity. So it was very, very important for like Pfizer and Moderna to get their vaccine, quote unquote vaccine, on the CDC schedule to give them immunity. Which, I mean, I make the argument, right? If you have a safe and effective vaccine, why do you need immunity? But they have it. So under the emergency use authorization, it was very important that they had immunity, and it was through the PrEP Act. And so once they had an FDA approved one, they couldn't have it on the market until it was on the CDC childhood vaccine schedule, because they wouldn't have had immunity. So there was like a window of time in between the vaccine, the FDA approval of commodity, and it wasn't available on the market until it was. And that window of time was so that the vaccine manufacturers could make sure they get it on the childhood schedule to get immunity under the 1980s law. So that's why it wasn't available, even though the troops were ordered to get it. And so, but unfortunately, so even civilians can't sue for vaccine injuries. Now they can file a claim with the government and maybe get into vaccine court, but likelihood of success is very low. Money that pays out very, very low comparatively. But service members were even more, so to speak, out of luck. So we could not sue. So we can't sue the manufacturers because they have immunity. We can't sue the government for forcing us to take a vaccine, right? If you have, and I know lots of people who are in the military who are forced to take this vaccine, and who are injured, who had heart conditions, or who are now being chaptered and med-boarded out because of their limiting conditions, that they're non-deployable. And they can't sue either. So they can't sue the government for forcing them to do it because the government has immunity. And service members cannot sue the government under the Federal Tort Claim Act because of the Ferries Doctrine. And I'm going to do a whole video series on the Ferries Doctrine as well. And so service members, they can't sue the vaccine manufacturers and they can't sue the government. And so the recourse that they have is VA benefits. That's it. And I've heard of, I don't know firsthand, but I've heard that that's been a struggle to get VA benefits for certain vaccine injuries. And so we're kind of left without a lot of recourse, unfortunately. But now we got a new administration, and we have the new EO. So let's look at that one. So sorry, let me pull it up. I don't have it ready. Remember, to get executive orders, just go to whitehouse.gov, click on executive actions, and then you can find, I'll share my screen. I'll show you what it looks like. And then you can find all the executive orders. So we're going to get into the executive order allowing service members. So again, it's just over 8,000 service members who were involuntarily separated for refusing the vaccine. It's allowing them to come back into service with back pay. But there's a caveat. I'm going to put like a little pin in it, and I'm going to say there's some offsets that are going to be for that back pay. And so I'll explain it. All right. So this is the executive order. This was January 27th, 2025. All right. So just kind of giving the background. So on August 24th, 2021, SecDef mandated all service members receive the COVID-19 vaccine, which we went over that. Secretary of Defense later rescinded that mandate on January 10th based on the Congress passing the NDAA, right? So there was a rider on the NDAA that passed that required within, I think it was 10 days of the NDAA passing, that the vaccine mandate be rescinded. So it's not like he did it out of the service of, goodness of his heart. Congress forced the DoD to do it. So this language in the EO says the vaccine mandate was unfair, overbroad, and completely unnecessary burden on our service members. I would use a lot stronger language if it were me, but that's me. Further, the military unjustly discharged those who refuse the vaccine, regardless of the years of service given to our nation, or if they were, Navy SEALs or Green Berets or people or helicopter pilots or, Navy fighter jet pilots, people that we poured thousands, hundreds of thousands of dollars into training, and then we kicked them out. Totally unnecessary. For failing to grant many of them an exemption. So in the Navy, and it's in the Navy SEAL case, the Navy had kind of a blanket. They even had, and if I can find it, I'll do another stream. They had a template that was given to all Navy commanders that was a blanket refusal of religious accommodation requests for the vaccine. So Navy commanders, essentially, at least my interpretation of it, that they weren't even given the discretion to grant religious exemption request. They were given a template. The template only had denial. It did not have the option to grant, and they did a blanket denial of essentially all religious exemption requests. So really, it felt like people with religious beliefs were being kicked out of the military based on those religious beliefs. This vaccine mandate was a really good way to weed out the critical thinkers, the people who would question orders, the people who may refuse to follow an illegal order, and religious individuals. This was like a really, really good way to put them all on a list and kick a lot of them out. So yeah, it felt personal. It felt targeted. It felt political. Yeah, absolutely. Yeah. So back to the EO, the federal government redress of any wrongful dismissals is overdue. Yeah. I think kind of more than that. I think people need to be held accountable. I think leaders at the top need to be held accountable. So I think that would go a long way to restore trust. So this EO says that we can make reinstatement available to all members of the military active and reserve who are discharged solely for refusal to receive the COVID-19 vaccine and who request to be reinstated. Enables service members to be reinstated under this section to revert to their former rank and receive back pay, benefits, bonus payments, or compensation, full back pay. Now, again, I'm going to caveat that. We're going to explain that's not totally the case. But that's been a couple of years. So they're going to go back to the same rank, but they've missed all those promotion opportunities, schooling opportunities. And that was a couple of years ago. So they're still going to be behind. So a lot of individuals missed, that's a couple of years. They could have made one, or if they're an enlisted soldier, maybe one or two, maybe three ranks in the years, right, that they weren't in the military because they were wrongly kicked out. All right, so service members can provide a written and sworn attestation that they voluntarily left the service. So if they voluntarily left because of the vaccine mandate, which I think thousands did, right? They either resigned or retired, or they didn't re-enlist, right? They just let they got out at the end of their contract instead of rather than taking the vaccine. This allows those individuals who voluntarily got out, to come back in, but they won't be given any sort of back pay, bonus, compensation. So you can come back in with no impact to your service, rank, or pay. So you'll come back in at the same rank that you left, but there's no back pay for people who voluntarily left. So back pay, a compensation, that's only for people who are involuntarily separated. All right. And then within 60 days, SecDef, has to implement this order. And so let's see what SecDef has issued. Let's see if I can share my screen for that. In the meantime, so let's see if I can make it a little bit bigger. All right. Okay, so this is what, let's see if I can, yeah, okay, here we go. All right, so this was initially put out by SecDef, Pete Hegseth, new SecDef, so February 6, 2025. It directed, okay, so let's go back and just read the whole thing because it's pretty short. So on August 24, 2021, then Secretary of Defense mandated all service members be vaccinated against coronavirus disease 2019, requiring the men and women of our force to subject themselves to an experimental vaccine. All right, I like that language. Yep, it was. That was unfair, overbroad, and unnecessary. The many thousands of service members who were discharged, regardless of their years of service to our nation, deserve better. It's time to make things right. I'm directing the Undersecretary of Defense for Personnel and Readiness to provide detailed guidance to the military departments no later than February 7, 2025, which is the next day. This guidance will provide procedures to rapidly reinstate individuals who are involuntarily discharged or voluntarily left to avoid vaccination. We need to do everything we can to recruit and retain a force that meets the highest necessary standards. This effort will help us reach this goal, Pete Hegseth. So know that these documents, I've only been able to find them on X, which is a little odd. I couldn't find them on the DoD website or on any of, there's a couple places that you can find like DoD directives. I couldn't find them on either of them. So I thought that was a little odd, but there is an official Twitter account that the DoD runs and the Army runs, and I believe that's where I got these. I know that it was one of the official accounts that was putting these out on X, and so that's why they're little photos. That's what I'm showing you is photos, because I had to take screenshots of them because I couldn't find the PDFs of them. Okay, so that's the very next day, right? So the undersecretary giving guidance. And so this is the guidance about those who want to be reinstated. All right. And again, and I think the guidance, it's several pages, but I still think that there's some unanswered questions. And so we'll explain that. And so if they were involuntarily separated, then it directs the boards of correction for military and naval records to exercise broad discretion in order to appropriate retroactive corrections of the service members' records in the attached memorandum, which we'll go through that too. And then service members who were voluntarily left or allowed their service to lapse, right? They didn't reenlist. They need to have broad communications that they have this opportunity to return to service. And know that the ones who were involuntarily separated, this memo directs that they need to be contacted in multiple different ways. So they need to be reached out by like phone or email and maybe even in person to let them know. They also will get like a letter in the mail saying, hey, here's this opportunity you can take, that you can come back in, have your rank restored, and with a 2-year service commitment. So remember that 2 years, you got a 2-year service commitment. All right. And then members where they voluntarily left, that's the military members should, or the military department should broadly communicate. So on social media, websites, newsletters, etc., to tell these people who voluntarily left that they can come back in service. And so let's get into kind of the details of it. Let's see. All right. So this was the attachment, the guidance that was given. And so, like I said, a public program inviting them to come back, that their records should be corrected. And remember, in the EO, it said that it's only for individuals who were solely left or refused to vaccinate if they were separated. Now, I can tell you that I've heard several stories of people who not only they were separated for refusal of the vaccine, but the command threw a whole bunch of other stuff in there too, right? So like gave them bad paper, threw them other things on there as well. So these individuals are going to be in kind of a different group if there were multiple other bases for separation. And usually it's kind of all connected. They're going to be in kind of a different group, like a secondary group, according to this guidance. So let's look a little bit more. This is about the outreach. So there should be, like I said, mailed written letter, electronic mail, so email if you can, or and a follow-up with a phone call to those. And remember, these are involuntarily. These are people who are involuntarily separated. And then they can get back pay, benefits, bonus payments, or other compensation. And here's the key language: subject to required offsets. All right, so this is what I think, in my opinion, hasn't been fully explained. So I haven't seen a full explanation as to what those required offsets are. Now, I've seen some rumors, some things on X that there's discussion about it. I think probably for sure veterans benefits, probably for sure going to be an offset, which kind of makes sense. It would be like double dipping, right? So if you got VA benefits during the time, the last couple of years, after the involuntary separation, likely that's going to offset any back pay. But I've also seen things that say that potentially even civilian pay. So, for sure, probably if you worked for the federal government, that would probably offset it too. So your pay, if you came in as a civilian, you got a job, then that would probably offset it. But then I've also seen potentially like civilian salaries, right? You go work in the private sector, you go work for a defense contractor, that may offset it too. So this back pay for some individuals may be zero, right? Because maybe they earned more money out in the private sector than they did in the military. So that's why I say, kind of with a caveat, the back pay issue. And these offsets haven't been fully explained. And I haven't been able to find a full explanation as to what they are going to consider to offset the back pay benefits and how they're going to calculate benefits, bonus payments, other compensation. That's not clear either. And so I think there's definitely more to follow on this. All right, so this is a lot about the outreach, pre-screening. So it directs the departments to go find these individuals, figure out who would be eligible, and then let them know that now they can come back in. They also, obviously they have to meet, if they come back in, they have to meet medical standards. They, they're going to give the Board of Corrections for their records are going to give these cases priority. And so their records should be corrected. Let's see. Let me look at the next. I think it's on the next page. All right. They can get, there should be here. Yeah. So for former members whose records are corrected to reflect a reinstatement to service, secretaries of the military departments will implement a process to facilitate an expedited estimate of all pay and benefits with DFAS, DHA, and other governmental agencies as appropriate. And so encourage the pre-submission of relevant information and documentation, tax returns, medical expenses by former service members to facilitate faster calculation and process of compensation fees. So it looks like that they'll also get like healthcare, right? So if you had out-of-pocket healthcare expenses during the last couple of years that you were, after being involuntarily separated, that you could get that paid. So that's a big deal. Absolutely a big deal. And then just more about the credited service, reservist, the retirement points to retirement. So, these are good things. And then following the receipt of their compensation payment estimate. So they'll get to know how much their back pay compensation package would be. Then they're going to get 60 days to decide whether to accept reinstatement. And then acceptance shall be in writing and include an acknowledgement of a 2-year service commitment. So actually, I don't think that that's super bad. So I've seen ADSODs way longer than 2 years. So I've seen them as long as 6. So 2 years is pretty good. And then, so then they would reintegrate into service. And then if they decline, they will not have their records corrected. So this really coming back for 2 years is the only way to get your records corrected. All right. And I think there's one more page of this, 2 more pages. Let's see. This is more about the outreach, right? That it should be tell people how to come back in. And then they can get waivers. They're going to return to the same rank and pay. And then this is for the former members that were voluntarily. They're not going to get any back pay, credit for lost service, or any sort of relief. All right. But then they can still go through the same process to have their records, if there was any bad paper or anything like that, their records corrected. All right. And then the service secretaries have to report back every 30 days. And then, all right. And then if it says nothing in this policy applies to service members or former service members who were subject to adverse action based on misconduct unrelated to their vaccination status. And then the COVID-19 vaccination mandate reinstatement and return to service policy will terminate 1 year after the effective date of this memorandum. So service members are going to have 1 year to decide to come back or not. All right. Let's see this one. And then, this is that undersecretary. All right. So I already looked at that one. All right. I'm going to stop sharing my screen. And then I'll look at my notes. Okay. So the big question is really on the offsets for back pay. And so if we get a further clarifying answer on that, I'll definitely do another live stream. I think it's a step in the right direction. I've posted this on X. I replied to Elon Musk when he posted this, that I really think that accountability and people need to be held accountable for what they put people through over the years of COVID. I'm sure a lot of you can relate to this, but masks were off. like people showed their true colors, and that really felt like I don't know, it was like mass hypnosis. So Matisse Desmond wrote a book, and I read it, and yeah, um, that really kind of explained it. This like mass psychosis, this mass hypnotism. I don't know. It's hard to describe it. Like I remember thinking, like I'm not the crazy one. Like everyone else is crazy. And you know what? I mean, I turned out to be right, and it was very hard. I lost a lot of friends. I'm sure people can relate. But you know what? I made a lot of good ones, and I found kind of I say my people. I found my people who are willing to critically think and uh, do their research. And you know, it woke me up. It woke me up. Now I don't trust any vaccines. So, um, yeah. So I think it's a step in the right direction, but I think more accountability needs to come before people are going to feel ready to come back into service. Um, and it's something. It's not going to help all my friends who took the vaccine when they felt like they had no other choice. The ones who are vaccine injured, the ones who had moral injuries, right? Who not only after taking the vaccine were forced to do a lot of things else that violated their own personal moral code. And so I think a lot needs to change. And I hope that Pete Hegseth is the right person to bring that change. And I hope we have a lot of change in the military because, I mean, I love it, right? Like I gave a lot of the best years of my life to military service, and it's family business, right? I mean, grandpa's in the military, Navy, Army. My dad was in the Army. My older brother was in the Army. I was in the Army. And I don't want my son to be in the Army, not this Army. Maybe it'll get better. I hope it'll get better. But yeah, I mean, it's real sad. Like it was definitely a tough, rough couple of years. And so I hope and pray that we're in the right direction and that we'll get the ship righted and that people will be held accountable. And another book, I'm going to go over that on another live stream, Crisis in Command, about the lack of accountability for the Afghanistan withdrawal. And so the author of that book is going to have Stuart Scheller. He's going to have a role in the administration. And so I think we're moving in the right direction. So thank you for joining me in this stream. And again, like I said at the very beginning, this is a personal and a very difficult stream. And so, but I hope you got something out of it. And if you like what I'm doing, please like, share, and subscribe. I'm a new channel, so please help me grow the audience. And if there's any topics you want me to cover, leave it in the comments. Definitely open to really providing the content that my audience wants to hear. So I said this before in the stream, definitely things for the future. I'm going to talk about the Nuremberg trials. I'm going to talk about the My Lai massacre in Vietnam. I'm going to talk about Crisis in Command. I want to go over that book. And obviously, I'm still going to talk about the current events, the current EOs, current military cases, and maybe in the future, be able to start to live stream some military subcommittee hearings, and we'll talk about that. And so thanks for joining me, and we'll catch you in the next stream. Have a good night.